Testing 1, 2, 3. Testing 1, 2, 3. Not hearing it?
Try again. It says this offline. Try now. Now should be okay. You guys have it.
Testing 1, 2, 3.
Good morning, everyone. We're here today on a Monday morning for oral arguments. We are going to begin with appeal numbers 24-1371, 72, and 73, Manassa versus NCAA. And Ms. Fegan will begin with oral argument from you.
Good morning. May it please the court. My name is Elizabeth Fagan, and I represent the appellants in this matter. This case is about the NCAA's promise to judge Division I student athletes' academic performance against the academic performance of the student bodies at their respective schools. The NCAA broke that promise and that contract by setting a single arbitrary benchmark in its academic performance program called the academic progress rate. And it applied that academic progress rate whether somebody attended an Ivy League school or a state school. That promise, or when it was broke and when it was set, NCAA knew that it would disproportionately affect and discriminate against Black student athletes at Division I historically Black colleges and universities, also called HBCUs. The NCAA set that arbitrary benchmark knowing that historically Black colleges and universities have a mission. That mission is to educate and provide opportunities for Black student athletes and Black students who might otherwise have been left behind by our educational system and our society.
Ms. Fagan, a couple of questions with regard to Plaintiff Freeman.
Yes.
Are you abandoning the argument that Freeman has standing based upon a hypothetical risk of the post-season ban?
Your Honor, our position is that she had standing based on the discrimination and the discriminatory impact and burdens placed by the academic performance program. I will admit that in our complaint, we focus largely on the effects of postseason competition bans. And
So on that standing question, are you relying on the racial barrier argument, not the postseason ban argument?
that's correct, Your Honor.
And you don't dispute that Freeman's alleged injury is moot. You're just saying she falls in the inherently transitory exception to mootness.
That's correct, Your Honor.
All right, thank you.
Yes.
What is her status right now?
She is no longer a student athlete.
Okay. And so she only played in college that 1 year.
That's correct. She played lacrosse, and she filed the lawsuit at the time that she was a student athlete. And under the inherently transitory exception to mootness, when it applies to class action claims. And so in the class action context, the courts will look at whether this is a wrong that perhaps we couldn't have gotten to in the judicial system. Here we have student athletes who are always moving through the system, who are graduating. We see that with McKinney. It just happened in the related lawsuit and with our intervener. And so courts will allow these claims to proceed if it's a wrong that will continue to happen because of the continued application here of the academic performance program.
Did you request that anyone other than Manassa, Plaintiff Manassa, be appointed to represent the liability class? I know that Freeman and McKinney were requested to represent the injunctive relief class, but anyone other than Manassa be appointed to represent the liability class?
We did not, Your Honor. We did request leave to do so within the context of our class certification motion, but the district court held that because we only did so in a footnote, that was not sufficient.
And you agree you only did that in a footnote?
I agree that we only did
And
that.
didn't propose any particular person?
We did not propose any particular person because at that point in time, Your Honor, we did not believe that the statute of limitations argument would be the bar that it was. Here in the Seventh Circuit, with respect to the statute of limitations, a civil rights violation, the statute of limitations accrues when the plaintiff knows that a civil rights violation has occurred, not when, for example, here, his basketball team was banned from postseason competition.
Ms. Fagan, if we, before we leave Ms. Friedman, another question. So let's assume that the NCAA policy was discriminatory, as you claim. And let's assume that there is some, that the barrier theory that you propose is applicable to, generally to the facts of this case, okay? My understanding is that Friedman's lacrosse team in 2019-2020 was not banned, is that correct?
That's correct.
Nor were the teams that came 3 or 4 years prior to that ban, right?
Correct. There was a time when they had
2013 or 2014,
Correct.
but well before that time. And as I understand it, the APP is based on a rolling 4-year, right, look back. And so given that, how do you think Friedman, even taking your theory for what it is, how can Friedman demonstrate that there was a substantial likelihood that she would have been impacted the next season when in fact the 3 teams before then weren't banned at all?
So, Your Honor, I believe that question is largely based on how we pled our complaint, but our complaint has something else. That ban is one of 7 levels of penalties that teams may have imposed under the academic performance program.
Well, are there any allegations in your complaint that her team and the teams for the prior 4 years faced any sort of negative impact from the NCAA policy?
Not in the context of penalties, but it's the burden, Your Honor. Because the burden here is that these student athletes must maintain higher grades than those at their respective student bodies, which is contrary to the HBCU mission. So the NCAA, when it set the APR, it did it considering race. It ratcheted it to ensure that students at predominantly white institutions were not burdened by the level at which it set, knowing that it would burden and affect historically black colleges and universities, that these penalties would be more likely to be imposed on historically black colleges and universities and their black student athletes. And so at the time, there was no way that this data and the rolling 4-year data and the methodologies on which it's based, there's no way for any student athlete entering an HBCU to know whether their team will be penalized during their 4-year stay.
See, the concern I have with that argument, and particularly looking at Northeastern Florida Associate General Contractors Robertson and Ledoux, is that there it was uncontested that the challenge policies and actions would, without question, impact the plaintiffs, right? And so, for example, in the Associate General Contractors case of minority contracting, someone who was not qualified as a minority contractor couldn't compete for those contracts, right? For those set-asides. Here, I think it seems to me that there is a significant question as to whether or not, had Freeman been on the team in 21-22, that team would have been impacted at all in any real way by the NCAA APP policy. So in that way, isn't the situation with Freeman distinguishable from the cases on which you rely?
I don't believe it is, Your Honor, because the APR is set on those teams no matter what. Those black student athletes at HBCUs have to work harder with less resources to meet the APR for their team, to ensure that there's no additional penalties, whereas that same burden does not affect Division I teams at predominantly white institutions. And so it's not just the idea of a penalty, it's the burden of having to work harder with less resources, with less tutors, black HBCUs don't have the same funding as an SEC school, for example. Certainly don't have the same admission standards as an Ivy League school, for example. And so setting a benchmark that the NCAA knows is going to penalize, for example, 70% of HBCUs when they make up just 5% of Division I schools, certainly shows that there is a burden regardless of whether there's actually a penalty. And that is not a burden that black student athletes at HBCU should have to bear. In fact, I know that the Supreme Court has said that it's not the ultimate inability to achieve success. It's not that there has to be an actual penalty. It's the imposition that there's any barrier or discriminatory program in and of itself. So we don't need to show, for example, that a ban was actually ultimately imposed. We have to just show that this program is discriminatory, or allege that the program is discriminatory, and that it was actually imposed on Freeman here.
You agree that the APP does not apply to Division II schools, correct?
I agree, correct. This is a specific Division I issue. And that it is, I just want to go back for a moment. It is really critical to the mission of HBCUs. HBCUs typically have very low academic requirements for admission, because they really are reaching in and providing educational opportunities for a group of people that might not otherwise be able to go to college. By imposing a singular rate on Ivy Leagues and HBCUs, the NCAA knows that it's going to require HBCUs to change their missions, to forego that, to raise their academic standards if they want to compete, and to only let in student athletes that can meet this arbitrary APR. And that's a violation or a breach of the contract. The NCAA promised to judge student athletes by the academic performance of their peers at their schools. I just briefly
Ms.
wanted
Vega, can I clarify
Sure.
one thing as to plaintiff Manasseh? The district court found that he did not have standing to pursue his injunctive relief because he wasn't a student at the time the complaint was filed. You are not appealing that ruling, are you?
I am not appealing that ruling.
Okay.
Our appeal as to Manasseh focuses solely on the statute of limitations. At
And
the
you agree that if he learned that he did learn of his injury on April 26th of 2016, correct? You're not disputing that fact.
No, we are not disputing that he learned of the postseason competition ban then.
So if the date he learned of the injury is the trigger date for statute of limitations, you agree that the claims are time barred as to him?
I agree that if the court finds that the knowledge of the ban itself is the trigger date that his claim is banned. However, he could not have known and did not have the data or the economist or statistician backgrounds, of which there's only a small circle of people that know how the methodology works. He could not have known that that ban was due to a civil rights violation.
How do you address our prior case, Thielen, then?
Your Honor, as I sit here, I apologize. I will know for rebuttal exactly what that case says. So I do apologize.
That was the case where it was an employment case, and we held that it's not the date when they determined why the adverse employment action took place. It's the date that they found out when it took place.
Your Honor, in the employment cases generally, there are typically facts that show that the person knew, even if they didn't know their right to a claim, they knew that a younger person was hired in their place, or they knew that they were replaced with someone of a different race. And so there are the facts available to them that allow them to know that a violation has occurred on the date on which they're terminated. That did not exist here. There was no knowledge. And in fact, even, we allege in our complaint that to today, the NCAA publicly states
But
that
our
this is not
case law
discriminatory.
doesn't add that caveat you're bringing in. Our case law and the Thielen case, which you could take a look at before you come back up here, makes clear that it's when he discovers that he's been injured. It doesn't bring in the discrimination or potential discrimination.
The Wilson case does say that a civil rights claim does not accrue on the date on which the wrong occurs, but the date on which the plaintiff knows or should know that his civil rights have been violated. And that's at 956 F. 2nd at 740. And here the undisputed evidence shows that he did not know. The NCAA has not submitted any evidence that he should have known on the date that his team was banned from postseason competition, that it was a civil rights violation.
Would you like to reserve the remainder of your time?
I would. Thank you, Your Honor.
Thank you, Ms. Fagan. Mr. Casey, we'll move to you now for argument on behalf of the appellee.
Good morning, Your Honors, and may it please the Court. My name is Brian Casey. I'm here on behalf of the appellee, the NCAA. The district court got it right in each of its decisions. It got it right in concluding that Jatah Freeman lacked standing. It got it right when it concluded on summary judgment that Mr. Manasseh's claims were time barred, and got it right when it denied our plaintiff's motion for class certification, and got it right with respect to proposed intervener McKinney that it was not an abuse of discretion to deny her to intervene, in particular when she had her own parallel lawsuit asserting literally verbatim the exact same claims. I'd be happy to talk about anything in particular that you would like to. We heard a lot about what the APP does and doesn't do. The reality is that these claims really were decided on things that have very little to do with the APP. Has to do with traditional notions of Article III standing, traditional notions of what Rule 23 is and what Rule 24 is. And so while I disagree with the characterizations that Ms. Fagan had about the consequences of the APP and how it is created, and I'd be happy to address those if that's what you would like to hear about. The reality is the decisions are based on much more well-established things that are in y'all's wheelhouse.
Ms.
So-
Casey,
I'm sorry.
go ahead.
You agree, though, that with regard to the district court's ability to add a replacement class member, the district court certainly has discretion to do that.
It has discretion to, it has discretion not to. They haven't pointed to any case that says it's abuse of discretion not to. And it's important to understand with respect to the substitute plaintiff argument, number one, it wasn't raised in a procedurally sufficient manner. Literally, it was one footnote in their motion for class certification. And who they proposed was, or who they talked about proposing, was Ms. Freeman, who had a final judgment against her that she lacked standing, and Ms. McKinney, who was the subject of her own motion to intervene, which the district court denied perfectly appropriately. And I'd be happy to talk about that if you'd like. So that there isn't any, that they didn't proffer any valid substitute plaintiff, and they didn't raise it in a procedurally sufficient way. I mean, the court has said any number of times that arguments that are raised simply in a footnote are underdeveloped and therefore waived.
They didn't file a motion for reconsideration on that aspect, did they?
No, they did not. And so, yeah, they simply didn't.
Mr. Casey, with regard to the Freeman standing question, specifically the racial barrier or discriminatory barrier theory, why does it matter whether the government, as opposed to a private party, is responsible for imposing the barrier?
Okay. It matters because that the case law doesn't really talk about that much, I'll be honest. Northeast Florida doesn't talk about that. Lac de Flambeau doesn't talk about, but in any of those cases, the language is when the government erects a barrier, and so we're not the government. If I could back up, though, for just a second. She spends a lot of time talking about the barrier theory. The barrier theory with respect to Jata Freeman was not raised in the district court. Please look at the opposition to the motion to dismiss. It simply wasn't raised.
Well,
So
docket entry 35, the response to the motion to dismiss, mentions it. Then there's an amendment of the complaint, I think it's docket entry 206, and it's not included. So there's a mentioning of it. The question is there a waiver?
Well, and if you spend time looking at the opposition to the motion to dismiss,
We have.
Okay. The argument that they're making is that Ms. Freeman is at an increased risk of a loss of access to postseason competition penalty, and that is that's also mentioned extensively in the complaint. The liability class is defined that way. Their discussion about why the statute of limitations is told, they say because every time there's a new penalty, loss of access to postseason penalty, it starts all over again. The focus absolutely was on loss of access to postseason competition.
And there's no question that postseason ban is mentioned 50, 60 times.
60
and
times.
Racial barrier
None.
a number of times. We've got to make that waiver call. But shifting back to this idea of the government versus a private party doing the imposition, you're correct that the case law doesn't directly address that. Here's your opportunity to tell us why you think the government, as opposed to a private party, should or should not be responsible for imposing the barrier.
Well, I think it is because these ordinarily come up in the context of government programs. And to your point, Judge Lee, earlier, the Northeast Florida is entirely different. There were minority set-asides where the plaintiff was not able to even apply. And the logic that they use is similar to the Bakke case. In Bakke, there were slots at the medical school that the white student was not able to even apply for. Here, that's not at all what's going on. Okay, and Judge Pratt's decision most recently, which we submitted as supplemental authority at the end, addresses this in more detail. Because part of what has happened here is plaintiff's theory has morphed over 4 years. So the theory that they're arguing now is really the theory that they argued in the second, with respect to the second motion to dismiss in McKinney. It is not what they argued before. But so, to your point, the government erects a barrier, prevents people from even applying. And so the standing injury is the inability to apply. You don't have to demonstrate that you would have gotten the contract, but you do have to demonstrate that you couldn't apply, okay? And that's what happened in, okay?
But isn't the argument that although the APP applies across the board to Division I sports, that it applies differently to the HBCUs? That is what causes the barrier. I think that's the argument.
That is the argument, and it is factually flawed and not
But we're at the motion to dismiss stage.
Understood, but you have to look at the motion, the complaint as alleged. And like I said, it's about it was about loss of access to postseason competition. Barriers aren't mentioned at all.
Yeah, that's a waiver issue. That's separate than
Sure,
the
but
substance of it.
Sure, but there still needs to be a barrier, and there isn't one here. And as the Supreme Court said in TransUnion, if you don't have a concrete harm, you don't have standing. Okay.
But we're talking about the merits. We're not talking about standing. The alleged barrier, I believe, to the extent it's in there, and I agree there's a significant waiver question, is that it applies differently to these schools.
Okay, we have to be clear as to who we are talking about. The Ms. Freeman is the one who did not, whose motion dismissed, or who did not have standing. Okay, she does not have any kind of concrete injury. Okay, she was not on a team when the complaint was filed. She never was on a team after that. Okay, and that's alleged in the complaint. She never was on a team in the 1 year she was there where that had a penalty, and as Judge Lee pointed out, didn't have the Howard women's lacrosse team didn't have a penalty for the 5-6 years before. Okay, in order to have standing for injunctive relief, you have to have, the injury has to be concrete and particularized, it needs to be actual and imminent. And under the barriers theory, and Judge Pratt goes into this in detail, this isn't a concrete or particularized injury. There isn't any concrete thing that happened to her that gives her standing, okay? It also isn't actual or imminent. It hadn't happened to her, and there wasn't anything more than conjecture that it might happen to her in the future. Okay, so the barriers theory, in addition to waiver, just fails on the allegations, and it's just not how this works. Okay, like I said, the fact that some schools, some HBCUs have less resources, and Judge Pratt talked about it here, that's not the NCAA's doing. Those are socioeconomic factors that, if they want to blame the Louisiana legislature for underfunding Southern University or Grambling, okay, but that's not the NCAA. The NCAA sets a uniform standard for every team at every school, and doesn't matter whether you're black or white, HBCU or not.
Mr. Casey, one could imagine, though, a world where the NCAA, rather than having a one percentage that applies across the board, would have a percentage that is benchmarked to the graduation rate at the particular school, right? And so for HBCUs, for example, where the graduation rate is significantly lower than, the Ivy League schools or what have you, and the NCAA's concern is that athletes not be given any special treatment, one can imagine a world where the benchmark would be basically, again, relative school by school, depending on their graduation rate.
One can posit that, and that's the argument that they are trying to have tried to make. Okay, that doesn't really directly address any of the reasons why any of the decisions, why any of the district court's decisions happened the way they happened. But it is also equally appropriate.
Just out of curiosity, is that something the NCAA considered, do you know, to your knowledge?
Well, now that we have been in litigation about this for 3 years, they have certainly considered it to the extent that they have raised it.
Right.
But as a general rule, what they have decided is that a 50% graduation rate is an appropriate benchmark for everyone, and some would argue that that's too low, but they've argued that that is sufficient, and that is what they have focused on thus far. And now keep in mind, Your Honor, and this isn't really germane to any of the claims that are here. There are a number of things they call waivers and filters that also apply to mitigate the fact that the APR might be less than 930 on the rolling 4-year average. I mean, we're now pretty far in the weeds of summary judgment and not what the merits of any of these decisions. But so they try to take that stuff into effect. So I guess I'd like to go back to the statute of limitations when that runs.
Can you address Ms. Fagan's argument that Wilson applies on the statute of limitations?
Yeah, that's some kind of loose language. It's still, as the Supreme Court said in Ricks, as this court said in Thielen and Lofton and Bradamus, and we cite all these in our briefs, the statute of limitations begins to run, either at the date that the injury that the act happens, or when you know of the injury. It is not when somebody tells you a legal theory that the injury might be allegedly unlawful. Okay, and the Supreme Court, like I said, pointed that in Ricks. It says when we told you you were going to be denied tenure, that's when the statute begins to run, not when you actually lost your job. Same with Thielen and Bradamus. Her argument kind of points this out. She points to the fact that we still don't believe it's discriminatory. On that theory, the statute of limitations would never run, or would never accrue, right? But the
So are you saying Wilson has been implicitly overruled, or?
No, I'm just saying it's loose language. I'm saying that the reality is it is when the plaintiff discovers that they have been injured that is the operative time frame. And there's absolutely undisputed that Mr. Manasseh was told that his team was going to get a postseason ban the following March on April 26th of 2016. And so he just is too late. And to your point, Your Honor, they aren't ever even challenging the fact that he doesn't have standing for the injunctive relief class, because he had been out of school for 3 years and therefore wouldn't get the benefit of any kind of changes. I guess I'd say very briefly, the denial of the motion to intervene also was absolutely not an abuse of discretion. Timeliness is a multi-factor test, and it focuses on prejudice to the original parties, and it was 21 months after the amendment deadline and after summary judgment and class certification briefing, and also she was able to litigate her own lawsuit and has been doing that to this day. She's lost every time, but she's been doing that to this day.
Thank you,
Thank
Mr.
you,
Casey.
Thank you, Ron.
Ms. Fagan, we'll go to you now for a rebuttal argument.
Thank you, Your Honors. I'll start with Thielen, since that was a question specifically asked of me. I think the critical thing with respect to Thielen is that in the employment discrimination context, there are specific time periods imposed and specific case laws to those cases, including with respect to the timing of filing an EEOC claim, et cetera. That is not true here. We're talking about college student athletes who are told about a team action. If someone loses practice time and is told they can only practice for 15 minutes this week, are they going to hire a lawyer to find out if it's because they're Black or because they're Hispanic or because they attend an HBCU or some other discriminatory reason? No, they are going to believe the NCAA and their coaches that it's because their grades weren't good enough. So I believe that Wilson is still good law, and I do ask that the court rely on that. Second, with respect to waiver, I think that there's a really critical issue here. Mr. Casey mentioned the definition of the liability class, but the definition of the injunctive relief class is not limited to Division I HBCU student athletes who were subject to a post-competition ban. It includes all student athletes at Division I, or all Black student athletes at Division I HBCUs. That's in the class definition at paragraph 214. But we also do raise it several times in the complaint, and we do raise it in the motion to dismiss. I agree with everyone that we focus on the impact of the postseason competition bans because it provides the most stark example of the discrimination here. But I do ask that the court look to see that the underlying theory there is the discrimination.
And you're relying there on docket 35, the response to the motion to dismiss, is that correct?
As well as the complaint, Your Honor, yes.
Okay, thank you.
Thank you very much.
Thank you, Ms. Fagan. Thank you, Mr. Casey. The case will be taken under advisement. We're going to move now to Appeal 24-2676, Moitke versus Moitke, and Mr. Maticelli, we'll begin with you.
May it please the court, opposing counsels, ladies and gentlemen. My name is James Macatelli. I am the attorney for the plaintiffs in this matter. Kevin Modicke is one of the plaintiffs. Catherine Torbick is another plaintiff, and JT, a minor, is a third plaintiff. This is a lawsuit that was brought against the defendants in this case for constitutional violations regarding an entry of an order of emergency order of protection that was entered on December 23rd, 2021, and then later vacated completely, and a read order of no unlawful contact was entered, and if in fact that order was applied with for 1 year, the entire case would be dismissed. And that's why it's important in this particular matter, because we're asking this court to reverse the district court's dismissal of the complaint based on the Rooker-Feldman doctrine.
Is the settlement agreement, Mr. Macatelli, part of the record?
Yes.
And do you happen to have the docket entry or the reference to it?
I believe it was 64.1.
64-1?
Right.
Is it your argument that the settlement agreement's incorporation of the resolution of the emergency order of protection, that lapses after the settlement agreement? The settlement agreement is still in effect. It's just that it had a 1 year expiration for purposes of them being able to return to court to effectuate it. Is that correct?
It's correct, Your Honor, but it is not effective. It is eliminated. It is dismissed with prejudice. The entire case is gone. So it was a temporary order that was to be, abided by the parties, and that's an important issue in this particular case too, because it eliminates the plaintiff's ability to really get their due course and to talk about their damages. The damages that we claim in this particular case.
But the order of protection is still extinguished. That was part of the settlement agreement, right?
It's gone. It's vacated.
Okay.
And Judge, I think that's an acknowledgement by the state court that in fact that order of protection was entered improperly.
Well, didn't the state court dismiss it or extinguish it based on the settlement?
Just on the fact that there was no longer going to be a hearing on the actual order of protection that would give a 2 year time frame as a final order or a final judgment. There's all these interlocutory orders that in fact are vacated and are no longer in existence. And that's what I asked the court to take judicial notice of. Those particular matters, although they were agreements along the way. It was to get rid of this entire case and to have our
Meticulously,
day in court.
is there a transcript from the state court proceedings? The judge who entered the order checked a box indicating that it had made findings orally and videotaped or recorded by a court reporter and incorporated into its order. But I didn't see a transcript or any indication of that record from the state court in the federal court proceeding.
Most of the conversations that occurred during the December 23rd, 2021 hearing for the emergency order protection that was entered ex parte,
Yes.
happened in the back room.
But
However,
it says there was a court reporter or some type of recording device.
there is a recording device, but it is very limited in what was discussed.
So that was never transcribed?
It was transcribed.
Is that transcription anywhere in the docket?
I believe it is. I couldn't address where
Okay.
it is at this point,
Okay.
but it is, Judge. And the box that was checked talks about considering factors under Illinois Statute 750 ILCS 60/214 small b to large b, which explain you try to balance the hardships in this particular case. What was entered was an order of protection, but also an order of possession of the residence that the plaintiffs leased from the defendant. The defendant had no right to occupy those premises.
So, Mr. Meticulously, you're turning to the argument, to the merits now. The district court dismissed this case based on the Rooker-Feldman doctrine. If the district court incorrectly dismissed it based on Rooker-Feldman, you have not raised in your briefing anything about the merits. Is that something we can address, or should we send it back to the district court?
That's something that I believe that this court can address also.
You haven't argued it anywhere in your briefs.
Well, because it's a jurisdictional question as to what's before this court right now.
I understand that. That's why my question is why you haven't argued it in your briefs, so we don't have the benefit of your briefing. How can we take it up if we reverse on the Rooker-Feldman?
Well, Your Honor, it's important. The reason that I bring up the facts of the case is because the plaintiffs are seeking damages. They sustained substantial damages. And in fact, the orders that were entered by the state court are not the only things that caused their damages. The unlawful conduct of the police officers and the defendant, Gary Monarchy, MD, when they gained entrance into the plaintiff's home. They used a locksmith to defeat the lock and then enter the premises. That violates the Fourth Amendment substantially. And
Are you saying that's fraud and corruption?
That's a tricky issue in this particular case, because I myself was one of the attorneys that was involved in the Hatsi-Tonopet case, and I asked this court for a rehearing, and it was an en banc hearing.
Understood.
Several justices agreed that fraud and corruption are exceptions. Some judges said, no, we're only going to consider fraud, so they didn't consider public corruption. And then in that particular order, it states maybe the Supreme Court should entertain this issue because there is a division in the Seventh Circuit, as well as all the other circuits. So I asked the court to take into consideration that this is a fraud case. A defendant, Gary Monarchy, goes into a court under color of law, gets an order, provides false information to the court, and says that he lives in the premises.
How is it fraud as to the officers? The officers had an order from the judge that they could go in and take possession, and the officers executed that order. I understand what you're saying about the defendant's fraud, but how is it fraud as to the officers?
The judge did not tell them that they could go and breach all of the constitutional rights of a party to their privacy.
They had an order to go into the home and take possession.
They had an order to serve that order, not to go into the home. And the moment they breached that door space, they violated my client's constitutional rights under the Fourth Amendment. There's case law that I cited in my brief that talks about that on the East Coast in North Carolina. The moment they forced their way into the premises, they've defeated the entire statute under the forcible entry and detainer rules.
So why not bring that case in state court?
Because, Judge, it's a constitutional issue.
You can have constitutional Madisonian compromise. You can have state You can have federal constitutional rights vindicated in state court. There's no preclusion of that.
Well, Your Honor, in this particular case, we were trying to get the state court to address these issues, and the state court would not address these issues. My clients are missing $500,000 of their property because not one court would enforce the orders that
So
were entered.
is your concern res judicata in state court?
There is no res judicata because everything is dismissed. So I asked the court, you need a final judgment in order for res judicata to apply.
So, which returns to the question, why not sue in state court?
Because the court that I was before stated they had limited jurisdiction. They could not handle
No,
civil matters.
new civil lawsuit attempting to effectuate Fourth Amendment or 14th Amendment constitutional rights.
Correct. One of the reasons is Dr. Monarchy is not a citizen of Illinois. He is a citizen of California. We asked the court to take judicial notice of the constitutional arguments. I believe this court is a more appropriate jurisdiction or venue to bring those claims before.
Let me direct your attention to the facts on the Rooker-Feldman question.
Yes, sir.
So you've been a participant in a lot of Rooker-Feldman litigation.
Yes, sir.
You did Hadzianovic. You're familiar with our Gilbank en banc opinion. In the Gilbank opinion, there was a change that occurred in the state court, and our court fractured on this question of whether or not there could be a damages claim with regard to a theory after the state court had effectuated a change. Second Circuit said the same thing. Sixth Circuit said the same thing. For example, the daughter had been returned. There had been a change in the state court. What change or difference occurred here? The Inverness home is no longer in your client's possession. There's been this slow drip of the property being returned through the pods, but we've got the same theory that's applied all the way through. There's been no change as a result of the state court. Isn't that correct?
Right. State court never addressed those issues. They continued to refuse to give us a hearing, and they kept saying that the parties had to resolve this particular issue. And that's why I want to stay away from the state court. I think it's very important to get a fair tribunal, impartial tribunal. I don't think we're going to get that in the state court because of the mistakes that were made in the particular state court. Judge, we also take into consideration that Gilbank case. It talks about we're not asking this court to reverse anything that happened in the state court. The state court did it itself. It vacated the order that was entered on December 23rd, 2021, and that was a big issue because when you vacate it, that means it's held for naught, that it never existed.
Well, you're asking us to review that determination, that decision.
And it's an interlocutory appeal issue. So the cases that we cite are the Kowalski versus Boliker, 893 F3rd 987. There's also a recent case that discusses the Gilbank case, Taylor versus Circuit Court of Cook County. So in this particular case, the facts are more in support of this court retaining jurisdiction because, in fact, nothing happened in the state court. We're not asking you to vacate any judgment. We're asking you to look at and to acknowledge that the state court did make a mistake, which I think the state court acknowledged by vacating all of the orders and dismissing the action with prejudice.
Would you like to preserve the remainder of your time?
I would. Thank you so much, Your Honor.
Thank you, Mr. McAtelly. We'll now move to Ms. Kunkel.
Yes, thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Kathleen Kunkel, and I represent the Village of Inverness defendants appellees. Along with me are the attorneys representing the co-defendants, co-appellees, Joseph Howard and Dr. Gary Modicki. With my time, I will be addressing the Rooker-Feldman issue, as well as touching on qualified immunity and appellants' 4th and 14th Amendment claims. Counsel for Mr. Howard will be addressing the absolute litigation privilege and failure to state a claim arguments. And counsel for Dr. Modicki will be addressing how appellants forfeited their right to challenge the trial court order by failing to address it in the state court, and claims against Dr. Modicki arguments. Now, Judge St. Eve, before I launch into everything, I want to come back to your question of appellants counsel about the hearing or the recording. Our view is no, that recording, a transcript of that recording is not in the record.
I didn't see it.
Yeah, no, we've confirmed that it is not in the
Okay,
record.
thank you.
Okay. And also, I do want to clarify the emergency order of protection itself, the document which is in the record, the box is checked where it says police enforced. What that means is the police can enforce that emergency order of protection. They can enter the house to do that. That is what that means. Now, Your Honors and Appellants Counsel had some discussion about Gilbank.
Ms.
And
Kunkel, I was troubled that the district court didn't even mention Gilbank. And we said, I know Gilbank is a fractured opinion, but I think we were all in agreement that the inextricably intertwined concept is gone, and that was really the basis of the district court's opinion here. So
Well, I
how
think-
can we
Sure.
affirm on that?
And this is exactly where I'm going with this first point.
Good.
So I want to lay out the timeline here because I think it's important. The district court's decision granting the motion to dismiss was entered August 28th, 2024.
Right, shortly after Gilbank.
Gilbank was entered August 1st, 2024. 2 days before the district court's order came out on August 26, 2024, we, the Inverness defendants, we made a motion for leave to file and cite additional authority, and we provided to the court and all of the parties with a copy of the Gilbank decision. And that's at docket 71 and 71-1.
Yes, you did exactly what you should have.
Now, I bring this back because I want to talk about waiver in the sense that I heard Appellants Counsel argue, and they argued it in their reply brief, that Gilbank should not apply because plaintiffs, appellants here, sought damages, right? But I want to note to the court, to this court, that it's important that appellants failed to argue in the district court that the reasoning and holding of Gilbank precluded a bar under Rooker-Feldman. And I've laid out that timeline for you.
But isn't it jurisdictional? You can't waive that.
You can. If you are the proponent of subject matter
District court,
jurisdiction.
that we have an obligation to look at jurisdiction on our own.
I understand.
You can't
but
waive subject matter jurisdiction.
you can waive the argument. Nobody ever waives subject matter jurisdiction, and Your Honor is correct. Every court has an independent duty to make sure it has subject matter
If
jurisdiction.
Gilbank precludes the application of the Rooker-Feldman doctrine here, which goes directly to jurisdiction, even if it wasn't argued by your opponent below, you don't waive that. We have an independent obligation to make sure we have jurisdiction. So I would move on beyond that argument.
Okay. Well, we've cited case law, and there is case law that holds the proponent of subject matter jurisdiction waives an argument that could have been made to support subject matter jurisdiction. And that's Travelers Property Casualty versus Good, 689 Federal 3rd, 714 at 718 7th Circuit, 2012.
Ms. Kunkel,
but even-
there are a couple of defendants in this case that weren't part of the state court action. Isn't that correct?
That's correct.
So the Rooker-Feldman doctrine wouldn't be able to bar any claims against them.
I think Rooker-Feldman does apply to bar claims against them, though, because
They
What
weren't parties.
plaintiff-
They weren't parties in the state court action, and so they can't be "quote unquote" state court losers, right? And so, why would the Rooker-Feldman doctrine bar claims against defendants who weren't even part of the state court action?
because the claims of the appellants or the plaintiffs themselves necessarily call for review and rejection of that state court order.
Right, but the fact that they need to be parties to state court action is an independent element, isn't it, of the Rooker-Feldman doctrine?
I suppose, Your Honor, it is. I mean, the first element of the Exxon test is federal plaintiff was a loser in state court, to your point. However, again, I think the fact that the appellants here, if you look at plaintiffs' amended complaint, if you look at their arguments here in the appellate court, all of the arguments derive from the actions of the defendants based on that state court order.
Right.
I mean, there's nothing apart from that.
To what Judge Feeney said, that's where the inextricably intertwined
Well-
kind of came in. But let me ask you another question. So the order of protection is now no longer in existence, right? It is.
I disagree. I disagree.
You disagree? You don't think it was vacated by the courts entering the settlement order?
I read that differently. I think appellants, by settling, they specifically agreed that that order would remain in place. Now, I understand that
But it says, and agreed to have the court vacate the emergency order of protection and stanter. I don't know how much clearer the language can be.
No, understood. But because appellants agreed to it, because the settlement provided the basis for the dismissal of the case, for the vacating of the order, it's not as if the order was vacated and then plaintiffs' appellants got to have possession back of the property.
The circumstances didn't change.
Correct. The circumstances didn't change. So I think that is, a distinction, respectfully, a distinction without a difference, if you will. And I did want to talk about the finality of the order. State law is very clear that the emergency order of protection is a final order. It is final. State law determines when an order is final. This order of protection is final pursuant to Illinois Supreme Court Rule 307, and then a case we cite, NRA TH 354 Illat 3rd 301 at 307 from 2004. And I do want to tie this into review and reject, because this case is the case to which Gilbank does not apply. If we're going to pass waiver and we get to Gilbank does not apply here. In Gilbank, the court specifically declined to announce a bright line rule that if a plaintiff seeks money damages, then Rooker-Feldman cannot apply. That door was left open, and this is the case that walks through that door. This case falls into that exception because although appellants sought money damages, they are specifically seeking review and rejection of the state court order. If we look at appellants' own words, in their opening appellate brief, they state at page 15, quote, plaintiffs are not trying to set aside a state court judgment. Okay, but they continue, quote, what plaintiffs are claiming is that the state court entered an exclusive order of possession without considering the required elements under the state statute, 750 ILCS 60/214 B2B. And then again at page 16, they state, quote, plaintiffs request this Court of Appeals to examine the state court's rulings and the state court's failure to review the requirements under the state statute. And if you look at their First Amendment complaint, all the factual allegations and the causes of action relate to this order. Appellants' own words are asking this court to review and reject the state court order, and that's specifically what Rooker-Feldman prohibits. That's the purpose of Rooker-Feldman. I would like to touch appellant's First Amendment complaint. All of the factual allegations, all of the causes of action derive from the state court order. And I just want to highlight, appellants could have attended court hearings, but they chose not to. They could have demanded a hearing to have the emergency order of protection set aside. They chose not to. And appellants never challenged the emergency state court order, either in the trial court or by an appeal. But they brought their appeal here, and that's what Rooker-Feldman precludes. They should have appealed it in the state court, but they didn't. They came here.
Thank you, Ms. Kunkel.
Thank you.
We'll move now, Mr. Yalapour, to you.
May it please the court, Ramses Jalapur on behalf of Attorney Joseph Howard, defendant/appellee. Your Honors, I'm here to argue a couple arguments. First and primarily that should the court find that Rooker-Feldman did not apply in the district court, that still the case should be dismissed on the grounds of the attorney absolute litigation privilege. That privilege, which not only protects attorneys, also protects litigants in litigation, and there only needs to be one element met for that protection to apply. And the quote, the only requirement is that the communication pertain to proposed or pending litigation. And that's in the appellate case in Illinois, Golden versus Mullen 295, ILAP 3D 865. That requirement here is clearly met. All the claims against my client, Attorney Joseph Howard, and 4 out of the 5 state law claims.
Does that privilege apply to the federal claims?
So, Judge,
To the 1983?
they do not, and we're not making that argument.
Okay.
There are no federal claims against my client. With respect to Dr. Modicki, there are federal claims against him, but we're not making the argument that the privilege applies to those. So with respect to my client, Attorney Howard, there are 3 state law claims. We are arguing that the privilege applies to all 3. With respect to Dr. Modicki, there are 5 state law claims. We are arguing that 4 out of the 5 are barred by the attorney litigation, or the absolute litigation privilege. The only one that wouldn't apply, that we're not making the argument for, is the conversion count 6, excuse me, of the amended complaint. But all other state law claims in this case, as against Attorney Howard and Dr. Modicki, are barred by the absolute litigation privilege. We did address this in the underlying case in the district court. It was fully briefed on our motions to dismiss, 2 motions to dismiss, fully briefed on both. Although the court didn't address or didn't rule on the privilege, it still can be a grounds for affirming here. And I rely for that point on Hero versus Lake 2027 Circuit opinion that says even if a court dismisses based on lack of jurisdiction, the appellate court can affirm on the merits. And here we have that in spades. The privilege clearly applies. And although the district court didn't rule on that ground, in a footnote, I believe it was, the district court did acknowledge that the privilege would at minimum apply to my client because clearly all the cause of action against Attorney Howard stem from his statements and his conduct in the underlying litigation. That is quintessential attorney litigation privilege. Aside from that, and I will just point out that yes, the appellants in this case didn't address that in the reply brief for some reason, but that's not our issue. It was briefed in the district court. We briefed it in our joint appellee brief. The fact that they chose not to acknowledge that has no bearing on us.
Thank you,
from our
Mr.
perspective.
Jalapur.
Oh,
Thank
you,
you.
Judge.
We'll now move Ms. Bushel to you.
May it please the court, Lydia Bushell on behalf of appellee Dr. Gary Modicki. I'd like to highlight 2 alternative affirmance grounds from the district court's findings that are supported by those findings even though they were not reached. They were discussed in the Rooker-Feldman analysis. First, appellants are seeking relief in federal court based on a theory that the state court's order was wrongly entered, but they waived their right to make that claim through their inaction and settlement in the state court proceedings. The district court below has already found, in the context of the Rooker-Feldman analysis, that appellants had the opportunity to raise the issues that they complain of in the state court proceedings, including constitutional challenges to the order of protection. That's at page 4 of the opinion. The terms of the order of protection itself advised appellants upon service that they had the opportunity to challenge the order if they believed it was not authorized under the law. An Illinois statute requires that if a petition challenging the exclusive possession is wrongly decided is filed in the state court, the state court has to hear that within 14 days. Yet appellants did not undertake any effort to challenge the order. I disagree with Mr. McAtelly's description of what his complaint in this case says. The only issues that were brought up in the complaint, and you can see the amended complaint at docket 53, paragraph 6 to 12, they're discussing the return of personal property. They are not challenging the exclusive possession element, which is what they had the opportunity to do in the state court. Instead, appellants affirmatively settled the order. They agreed to the very part of the order that they now say was incorrectly entered. They agreed to Dr. Modicki's right to exclusive possession of the residence. Appellants should not be allowed to ask a federal court to determine that an order was wrongly decided after they did not even attempt to have the order set aside in the state court, and in fact contractually agreed to abide by the key term. The Section 1983 claims and related state law claims can and should be dismissed on this ground as well. Quickly, Section 1983 claims against Dr. Modicki should be dismissed because he is a private citizen and not a state actor. Appellants argued below that Dr. Modicki is a state actor because he conspired with the court and then with police officers to have the order of protection entered and enforced. But in its dismissal order, the district court summarized appellants' fraud and conspiracy allegations and found they failed to satisfy Iqbal and Twombly, let alone Rule 9. The Section 1983 claims against Dr. Modicki, which are based only on that alleged conspiracy that the district court found was insufficiently pled, must accordingly fail. Thank you.
Thank you, Ms. Buchel. Mr. McTelly, we'll move back to you now for rebuttal argument.
Much has been argued about.
Can I ask you a question right away? You're not attempting to void the settlement agreement, is that correct?
Your Honor, the settlement agreement no longer exists. It was dismissed with prejudice.
So you're saying that once it was dismissed with prejudice, everything about the case is just gone?
100%. And that's why these are temporary orders. They were to keep order between the parties. And what's important for the court to
I don't understand how this settlement agreement doesn't exist. You could say the state court action doesn't exist, but the settlement agreement, you entered it, and it was your agreement. I don't understand how that doesn't exist. Maybe the terms have been complied with, so you no longer have to do anything with respect to it. But to say it doesn't exist doesn't make sense.
Your Honor, it does not exist. It was when the case is dismissed. It is no longer in existence.
You could not abide by the terms of it anymore after the case was dismissed?
There was a time frame in that order that we had to do it for 1 year, and after that 1 year, the case would be dismissed along with the agreements. There is nothing pending in the state court whatsoever, and that's a problem in this particular case because the opposing counsel said we didn't appeal certain decisions, but we didn't have a right to appeal. We never got a final judgment under Supreme Court rules of
Because
Illinois.
you settled the case. I mean, if you'd fought it to a judgment, then you could have appealed. But when you settle a case, by definition, you can't appeal it.
But, Your Honor, the settlement was a temporary action in that action. Once nothing happened between the parties for 1 year, again, the case is dismissed. It is not closed. It is actually dismissed with prejudice. There are no claims pending between any parties
That
whatsoever.
sounds like it's closed to me, if it's dismissed with prejudice.
But what's important for the court to understand is in this particular case, the defendants in this particular case and the plaintiffs, the plaintiff in this case, which was the defendant in the state court case, got a benefit also from the agreement that was entered. It was no unlawful contact between the parties, which it's a normal law that you cannot cause difficulties with other individuals or do unlawful acts anyway. So what that agreement was is that we would not cause difficulties between each other.
Was there anything in the order of that actually dismissed the case with prejudice that specifically said the settlement agreement was vacated as well?
Yes. No, strike that. The order of protection was vacated.
Right.
And then there was a temporary order or a dismissal without prejudice.
Right.
And if in fact the parties were to abide by the agreement, the case would be dismissed with prejudice. And I think that's an important factor.
So you're saying that all the obligations that the parties agreed to in the settlement agreement are no longer binding upon them?
100%. They're no longer to abide by those particular rules. They could
But
do
your
what they
client
want.
can't go back in the Inverness residence.
He cannot go back into the Inverness residence.
So then the terms would still apply.
But the lease, Judge, that they had allowed him to have possession of those premises.
You're going back to the original argument that if your client can't go back and live in that residence, then the terms of the settlement agreement still apply. That was the whole point of the emergency order protection, was to get your client and his girlfriend and the child out, right?
And Judge, I would disagree with that, and I would say that the Illinois law itself prohibits my client from going into that home and trespassing. He does not have a legal right.
Well, let's talk about, there's another provision where the parties agreed to refrain from making any disparaging statements against one another, right?
Correct.
And your position today is that that obligation no longer binds the parties?
That obligation no longer binds the party because that agreement was only for 1 year.
And where in the agreement does it say it's only for 1 year? I can't find it anywhere.
Well, what it states is that if you abide by this agreement for 1 year, the case would be dismissed with prejudice. Since the case is dismissed with prejudice, anything
But it's
in that
dismissed.
case,
But it's dismissed with prejudice according to the terms of the settlement agreement, right? And so the settlement agreement is what effectuates the dismissal with prejudice. Without the settlement agreement, there wouldn't have been a dismissal with prejudice.
but there's a time frame that agreement is for 1 year. The parties are not to do any unlawful
We're being
acts.
loose with our terms here. The agreement wasn't for a year. It was that the case would be dismissed after a year.
Right, and once the case is dismissed, I believe that agreement is, part of that case is also dismissed. It's a temporary type
The
order.
1 year agreement is what gave the court jurisdiction to enforce it if the parties didn't comply with it during that 1 year.
During that 1 year. Now the court
But it
has
doesn't
no
go
authority.
away, but that's because the case is closed, not because the settlement is no longer good.
But if the settlement was good, that court would always retain jurisdiction to enforce that agreement. So I asked the court to
That's
take that
not
into
true
consideration.
because the court loses jurisdiction once it closes the case.
Once it closes the case, most likely.
With prejudice. When it's dismissed with prejudice, you lose jurisdiction.
Correct.
You'd have to file a new suit.
Correct, but everything in that case is dismissed with it.
Thank you, Mr. McAtelly. Thank you, Ms. Kunkel. Thank you, Mr. Jalapour. Thank you, Ms. Buchel. The case will be taken under advisement. We are now going to move to Appeal 24-3091, Singh versus Bondi. Mr. Kraus, we'll begin with you.
Good morning, and may it please the court. My name is Ben Kraus, and I represent Gurkirat Singh. Mr. Singh is challenging the Executive Office for Immigration Review's denial of his application for asylum and withholding of removal. And with my time this morning, I want to address three main points. First, that the agency erred in finding that Mr. Singh did not suffer harm that rose to the level of past persecution. Second, I want to address whether substantial evidence supports the agency's conclusion that he could reasonably relocate within India. And finally, I want to address the agency's error in applying the incorrect standard of review when it internally, the BIA, reviewed the immigration judge's decision. And I want to start first with the agency's conclusion that Mr. Singh did not suffer harm rising to the level of past persecution. And I identify two distinct types of errors the agency made here. And the first one is it parsed out and segmented out the types of harm that Mr. Singh suffered instead of considering them all in the aggregate. And when we're looking at this case today, we benefit from the fact that there is no meaningful dispute about the facts here. Mr. Singh joined a fringe Punjabi party, and within 18 months, he had been violently attacked 2 times by members of a national party who beat him the first time for more than 10 minutes, more than the length of this argument, with wooden weapons. And the second time, they did it again, beating him for at least 10 minutes around his body, causing him to yell out with pain. And in the middle of this attack, or during this attack, they said, quote, "This time we will kill you." The agency concluded that a couple of things. One of them was that this attack the 2 physical attacks that they suffered did not rise to the level of past persecution. And they compared that to this board's precedent in Chuchman and a few other cases. And then in a separate paragraph in the Board of Immigration Appeals decision, they said, well, also the death threat, "this time we will kill you," does not separately amount to past persecution because it was not immediate and credible enough the way, for instance, this court has treated death threats in NLA. And the mistake there legally is it's doing this parsing out of the different kinds of harm and measuring physical harm against a case involving solely physical harm, Chuchman, and threats against...
Did you make that argument below? It seems like you did not exhaust your aggregation argument, which you're raising before us now.
I think throughout the case, we assumed sometimes that harm is being aggregated. And I wish that I'd used aggregate or a citation to this court's decision.
Even not using the word aggregate, just the way it was presented below, it seemed as if you segregated them. And the way you talked about physical harm, and then you talked about the death threat, rather than combining it. I'm not saying you have to use the magic word of aggregation.
Yeah, and I've reread my own brief here, and I wish I had been clearer in describing the threats in the aggregate there. But I think the main and clearest example of this reasoning happened from the Board of Immigration Appeals decision after I had submitted my brief in this case. So I think the error should not be deemed waived, because the board continued to make the same error in its decision. In fact, in its clearest form of segmenting the two forms of hardship out. But even setting aside the legal error here, I think substantial evidence doesn't support the agency's conclusion that this harm doesn't rise to the level of past persecution. I think now is a time to address this court's decision in Kamaljeet Singh versus Garland, last year's case involving, in many ways, very similar facts. But the distinction here between, as this court parses out Kamaljeet Singh from Gurkirat Singh's case, is the use of weapons and the immediate death threat involved in that second attack, where if not for the bystanders who interrupted the attack, Gurkirat Singh may have been actually killed in the moment. I think both of those things do elevate the hardship, the harm of Mr. Singh's case beyond that of Kamaljeet Singh in the prior case. But I do also want to address whether substantial evidence supports the agency's conclusion that Mr. Singh did not or could have reasonably located within India. The reasoning seems to rely on the fact that Mr. Singh is a relatively young male and in good health. Those are the factors, and I think those are all very good and relevant factors to analyze when a court is looking at whether it's reasonable to relocate. But the other factors the court essentially ignores. Mr. Singh is a Punjabi speaker. Punjabi speakers make up about 19 million of India's billion-plus population. He is...
But the court didn't ignore that. The court noted he was able to come to the United States, and he didn't speak English when he came to the United States.
Yeah, and Your Honor, I think that the U.S. analogy is a really good one, because in the United States we have, especially up in Wisconsin where I live, a large community of Punjabi speakers where it's relatively easy to find work, find someone to take you to the DMV to get a driver's license. There's a big community of people who can support you here in the U.S. And perhaps there may be in other parts of India as well, like neighboring Haryana state. But it's not that he can simply move to any part of this immense country and relocate. In fact, the government's own country condition evidence that they submitted in the record at page 208, the government's records suggest that it would be very difficult for a uneducated Punjabi farmer to relocate to another part of India. And so when we look at what is reasonable under the circumstances, I think the very difficult move of picking up and beginning a new life in a place where you don't speak the language is extremely important. Lastly, I did want to address...
Before you move off of that point, did you offer any evidence below that low-level Man Party members are, to rebut that low-level Man Party members are not targeted outside of Punjabi?
There's no evidence on the record to suggest that that low-level Man Party members would be targeted outside of Punjab. There were several instances in our filings that document party workers being harmed in Punjab, but not outside of Punjab. Those are separate issues, though, as the immigration regulations look at in 8 CFR 1208.13. The issue of whether you're going to be harmed anywhere in India is one part of it, and then the reasonableness of having to pick up your life and begin a new life somewhere else in your country is the other factor. And so I think I'm relying.
You're not contesting then that what you just said was the first factor about low-level man employees not being targeted outside of Punjab.
I think that does get to the first factor, whether it's possible to relocate. The way that sometimes it's set up is, can you relocate, and then would that relocation be reasonable? I think that gets to the first, whether it's possible. The last thing I did want to address is the burden of or the standard of review that the sole appellate immigration judge applied in looking at the immigration judge's decision. Board precedent affords Mr. Singh a de novo review of that mixed question of fact and law, where you take undisputed facts and apply them to the law. It's quite unlike the court's standard that it's applying to the facts here in this case, but it is one that the board has announced in matter of ZZO and matter of RAF.
Why doesn't the board's reference to Bourbano cure any standard of review question?
Yeah, to be honest, I was actually a little bit puzzled by that. I'm sorry, I wasn't able to wrap my head around that. The court in Bourbano, the board adopted the reasoning and ideas of the immigration judge below, but we have no idea the scrutiny that it applied in making that decision to adopt those factual findings and those legal determinations. In fact, the only clue that we have is it repeatedly, the appellate immigration judge says, we find no clear error on just about every one of its decisions, which appear on their face to be mixed questions of fact and law. And if there's nothing further,
To reserve the remainder of your time?
I would like to. Thank you.
Very good. Thank you, Mr. Kraus. Ms. Pino, we'll move to you now for argument on behalf of the appellee.
Good morning, Your Honors, and may it please the Court. Tatiana Pino for the Attorney General. The Court to deny this petition for review because substantial evidence supports the agency's denial of asylum, withholding, and CAT protection. Under this highly deferential standard, the record does not compel reversal of the agency's reasonable conclusion that petitioners' past harm in Punjab, India, by members of the Congress Party did not rise to the level of persecution. I'd like to address some of the points on this related to past persecution that petitioner addressed, as well as the relocation issue and the standard of review issue. First, as Judge St. Eve pointed out, petitioner never exhausted the cumulative harm argument. In this court, exhaustion is mandatory. That is also confirmed by the Supreme Court's recent decision in Santos Zacharias, so the court should not even entertain that argument. Even so, the argument falls flat on its face on the merits, particularly with regard to the threat. It's one thing for, just because the agency discussed in separate paragraphs physical harm and threats doesn't mean that those facts were considered separately. In fact, if you look at the agency's discussion of the threats, it is discussed in the context of the November 2017 physical assault. And the agency considers that it was uttered right before or during the physical assault, and it looked at the injuries that resulted from that assault to find that those injuries did not suggest that the threat was credible or imminent. So there you see in the agency's discussion, it's not discussing the threats in a vacuum, but rather in the context of the physical assaults. Next, petitioner tries to distinguish Kalmajit Singh, but his attempt should be seen as meritless. As he points out, the petitioners in both cases were injured with the same types of weapons. There was actually a threat in Kalmajit Singh. The threat was a little bit different. It was a threat that the petitioner will suffer consequences, and it was uttered as the assailants fled in the second attack. But nevertheless, there was a threat in that case as well. And the nature of the injuries are very similar. In both cases, you have bruising and swelling. But actually, in Kalmajit Singh, you have arguably worse harm. You have the petitioner in that case suffering broken teeth and requiring stitches to his head. And so even with those facts, this court held that the record did not compel reversal of the agency's past persecution determination. Moving on to relocation, it's petitioner's burden to satisfy two requirements for relocation. The first is to show that internal relocation would be unreasonable for him, and the second is that it would be unsafe for him. He conceded today that safety is not an issue, and by conceding that point, that really closes the matter about internal relocation. And just more to the point, he conceded he was a low-level man-party worker, and that would be of no interest to central authorities in India. And
He didn't concede the first point, though, and you need both.
you need both. Yes, you need both, and that's under the regulations. Just to talk about the reasonableness factor, the agency expressly considered his Punjabi language argument, as Your Honors pointed out, and found that it was reasonable to expect him to relocate, given his ability to successfully relocate in the United States, where English is the dominant language. He's away from his family. He's young. He's healthy. I believe he's almost 30 years old. Moreover, the DOJ report at 206 of the record explains that there are Sikhs all over India, and it explains that internal relocation for Sikhs in general in India is not an issue so long as they are outside of Punjab. And turning to the Bourbono and standard of review point that he made, so let's look at, I want to make 3 points here. The first is the board expressly acknowledged the different standards of review at record page 3, I believe it's the second paragraph, according to its own regulations. So we see the board's express acknowledgement of the different standards of review. The second point is, what does Bourbono mean? Adopting, and this is coming straight from the Bourbono decision, it explains, adopting or affirming a decision of the immigration judge under Bourbono means that the board is in agreement with the reasoning and result of that decision. A Bourbono affirmance is a statement that the board's conclusions upon review of the record coincide with those of the immigration judge articulated in the decision. And so when you think about a Bourbono affirmance, you could essentially, it's a full adoption and affirmance. And it's almost like an incorporation of the immigration judge's decision.
We've said you can't just merely parrot the correct standard of review. Why isn't just referring to Bourbono here just parroting the standard of review?
Well, it's not only doing that. You have the board also addressing petitioner's arguments on appeal separately. And that's where petitioner gets his arguments that there was essentially only a clear error review, but that's actually incorrect. If you look at the board's decision, let's start with the past persecution determination. You could find at the first full paragraph of page 4 of the record, right before the citation to Singh v. Garland, you have a statement by the board that is affirming the IJ's legal conclusion that the harm that petitioner experienced in the 2 separate attacks by Congress Party members was not severe enough in type, scope, or duration to rise to the level of persecution under the INA. So you have, even that phrase, under the INA, shows that the board is applying facts to law, and there's no clear error statement in what I just read. And that is affirmance with the legal conclusion. Then to support that affirmance, it says we discern no clear error in the findings that petitioner experienced 2 separate attacks by Congress Party members. He saw a doctor, and he suffered swelling and bruising, and there was a second attack that required ointment for scratches. And so you see a recitation of the factual findings reviewed for clear error. Same for the internal relocation conclusion. You have, and this is a quote from record page 4, the IJ correctly found that petitioner did not meet his burden of proving that he could not reasonably relocate to avoid future persecution. That is an agreement with the legal conclusion, and to support that, the board says we discern no clear error in the IJ's findings that he was a low-level worker for the Man Party. There's insufficient record or evidence that he was targeted for harm outside of Punjab, or that he can reasonably relocate in India. So taken all together, it's very clear that the board applied the correct standards of review contrary to what petitioner is claiming. And I'll just highlight, I'll end on the standard of review here. This is the highly deferential standard of review, the substantial evidence standard. The court can only reverse if it finds that no other reasonable fact finder could find as the agency did here, and the record does not compel reversal.
Thank you, Ms. Pino.
Thank you so much.
Mr. Kraus will move to you now for rebuttal.
Thank you, and I'll be brief. The only point I wanted to raise in rebuttal was The government has suggested that you have to show that Mr. Singh would have been persecuted all throughout India, and his relocation would have been inappropriate. But I don't actually fully understand what that means. If his relocation is not reasonable, if it's not a reasonable life that he could have in a different part of India, we have met our burden that he cannot move to another part. He doesn't have to live in hiding or as court precedent has held. Maybe or in extreme poverty. These issues don't seem like two separate issues. Thank you.
Thank you very much, Mr. Kraus. Thank you, Ms. Pino. The case will be taken under advisement. The court's going to take a brief recess at this time. We're going to continue with our fourth case of the morning. This is appeal numbers 24-1652 and 1685, United States versus Russell and Williams. Mr. Chavari, we'll begin with you.
Good morning, and may it please the court. My name is Matthew Chavari, and I represent one of the appellants in this case, Mr. Philandus Russell. I'd like to reserve the 2 minutes of my time for rebuttal if I have it to reserve. First, the district court clearly erred by determining that Mr. Russell was competent to stand trial. The evidentiary record before this court shows this in two key respects. First, the district court disregarded Dr. Jaco's assessment of Mr. Russell. And second, the suggestion that Mr. Russell's level of competency was improved in any fashion while at FMC Butner is absurd and fundamentally conflicts with the evidentiary record before this court. We look first at Dr. Jaco's testimony.
It seems to me that you are just arguing the court should have given different weight to Dr. Jaco's testimony, because the district court very carefully went through her conclusions and indicated why it was not giving her opinion the same weight as the other two doctors. To say that the court, I think you said categorically disregarded in your briefing, just it seems like you're asking us to weigh it differently.
Your Honor, in that regard, the quantity does not beget quality, volume does not beget value. While it is true that the district court did take time to go through Dr. Jaco's assessment, that is not the same as considering.
But the court did consider it. It just found it had been rebutted by the evidence. She had not looked at school records, had not looked at the Social Security records. The court went through pretty carefully assessing her reports and saying why it didn't believe them, or why it didn't put the same weight into them.
So Dr. Jaco did look at the school records. There were
I misspoke. It was the Social Security records.
Yes, but even those made a clear, consistent record, a clear history of Mr. Russell's well-documented learning disabilities that included, most importantly, an IQ of only 54, cognitive deficits that followed him throughout school. And this was unrebutted and agreed to by Drs. Mukin and Dinwiddie.
When we're getting, though, determinations of disability and then two determinations of malingering, don't we have to be deferential in those circumstances?
Yes, Your Honor, but the distinction between malingering and cognitive ability has the ability to be empirically supported, and there are limitations. Even Dr. Mukin admitted that there are severe limitations to an expert's capacity to measure and document malingering, and also admitted that there's no data in any learned treatise, journals, or anything else that an expert in her field would regularly rely on that would allow them to indicate those comparative percentages. So simply put, the malingering is not supported by empirical data. So in that regard, again, the district court certainly went through and made reference to Dr. Jaco's findings, but based on the determination, it's clear that those were disregarded. It's not simply a matter of differing weight.
What about the testimony at the hearing about Mr. Russell's different behavior towards different people when he went to the institutional facility?
A fair point, Justice. What the district court...
Judge Lee.
Don't give me a promotion.
Pardon me. The district court did raise concerns about that in looking at specifically Dr. Dinwiddie's testimony, and said specifically that Dr. Dinwiddie cannot really say how Mr. Russell's conduct during his interview connects with the tests administered by Drs. Jaco and Mukin. So that is more anecdotal, and again, Dr. Dinwiddie, importantly, did not retain notes, did not conduct any tests to allow the district court, or this court, or any court for that matter, to empirically weigh or measure this concept of purported malingering.
What about the testimony?
Go ahead.
What about the testimony that Dr. Dinwiddie had suggested that a symptom of being cognitively impaired to the point where you couldn't testify or couldn't stand trial was that you shuffled your feet, which is not such an example of it, or not such a symptom of it. And then your client, after he heard Dr. Dinwiddie say this, which he intentionally said in his presence, started shuffling his feet and doing exactly what Dinwiddie had planted there to say was indicative of psychopathology. That's pretty strong evidence.
I would respectfully disagree that we have an anecdotal report of that incident. Dr. Dinwiddie, of course, also testified that he was not qualified to test Mr. Russell's IQ, even if he had wanted to. So I think.
But that's separate than testing IQ. Are you saying we can't rely on Dr. Dinwiddie's testimony that he observed your client shuffling his feet after saying this?
I think in the balance of all the evidence presented to the district court and that weighed by this court on balance, I think even in spite of that, it does still lend towards the court disregarding and not simply weighing greater the two experts. And in my remaining time, it's true the district court's procedural error when it comes to Mr. Russell's unreasonable, excessive, and above guidelines term. This court cannot have confidence that the district court meaningfully considered Mr. Russell's principal arguments in mitigation. The court here again paid some service to the mitigating factors of Mr. Russell's unrefuted cognitive impairments, but because that did not rise to the threshold of competence, whatever articulated mitigating value that the district court afforded these arguments was clearly controverted by a corresponding aggravating value assigned for malingering. Simply put, he was punished for purported malingering. And this
Thank you, Mr. Shabari. Thank you.
Thank you.
Mr. Hillis, you can hear us and see us?
Yes, Your Honor.
Very good. I'll recognize you.
Thank you. May it please the court, counsel, my name is Daniel Hillis. I'm with the Federal Public Defender's Office, and I represent Terrence Williams. Mr. Williams is here on one challenge supervised release condition, and the government agrees that a remand is necessary because the condition is overbroad and vague. However, we have additional concerns that we want to amplify to perhaps spare a second round of appeal should the same condition be effectively imposed. So our concerns reach beyond the ambiguity and overbreadth. Those are surely some of our concerns here, but the non-delegation of authority in violation of Article 3 remains a concern of ours, as does the compulsory government speech.
Mr. Hillis, if condition number 13 is modified to require Mr. Williams to consent to notification by the probation officer rather than to notify a third party himself, would that satisfy your concerns?
It would not, Judge, because that's functionally the same as compulsory speech in the first instance by requiring my client to make a disclosure of a risk that he doesn't agree that he poses. So I don't think there's any functional difference between making my client disclose it versus requiring him to allow the probation office to disclose it.
What if it requires his consent, though?
I think that's semantics. It'd be the same thing. So we think that we just need to remove my client from that equation, not require him to do anything, not to consent to a disclosure. Our remaining concern, though, is the non-delegation, and so I would turn briefly to that. And allowing the probation officer, who's not an Article 3 judge, some authority to determine an aspect of punishment, we think flies in the face of this court's authority. And we cited Wagner and Schrody for that, but also the Supreme Court's determination, or rather decision, in Spendthrift Farms. So we would rely on those principles to support our non-delegation argument. With that, I reserve the balance of my time for rebuttal.
Thank you, Mr. Hillis. Mr. Maurer, we'll move to you now for argument on behalf of the appellee.
Good morning, Your Honors, and may it please the Court. The District Court's finding that Philandus Russell was competent to stand trial was not clearly erroneous. two independent experts, Dr. Marina Mukin and Dr. Stephen Dinwiddie, each determined that Russell purposely exaggerated his intellectual disabilities, and that in reality, he adequately understood the nature and consequences of the proceedings and could assist in his own defense. Although Dr. Melissa Jaco believed that Russell was incompetent, her finding was against the weight of expert opinion. More importantly, the district court found that Dr. Jaco failed to properly consider whether Russell was malingering, and that her opinions were based on an incomplete assessment of the record. Due to the severe flaws in Dr. Jaco's examinations, the district court properly discredited her findings in favor of Dr. Mukin and Dr. Dinwiddie. Russell now tries...
There's a lot of focus in the testimony and the ruling on malingering, but what is the strongest evidence of Mr. Russell's capacity to understand the proceedings and communicate with his lawyers?
Both Dr. Mukin and Dr. Dinwiddie met personally with Mr. Russell. They went through his school records as well as the Social Security disability records. And through those examinations and those assessments, they determined that he could communicate effectively, that he could advocate for his own needs, sometimes strongly, and that he could understand things communicated to him with assistance. And those examinations and observations were further reinforced by the district court's review of Mr. Russell's recorded jail calls, which reinforced all the same points. Russell now tries to mischaracterize the court's discrediting of Dr. Jaco as a complete disregard for her opinion, but the record contradicts that claim. It was the district court who appointed Dr. Jaco to serve as Russell's first competency evaluator. The court then considered not one, but two of her psychological examinations. It listened to her sworn testimony during the competency hearing, and then devoted nearly 5 pages of its final competency ruling to rebutting her analysis. Thus, far from ignoring Dr. Jaco, the court merely found her opinion less persuasive, which it was empowered to do in the exercise of its sound discretion. Russell now seeks to relitigate that assessment, but credibility decisions can virtually never be clear error. The district court observed all 3 experts testify during a 2-day hearing, and it was therefore best positioned to assess and weigh that testimony in light of the entire record. Turning briefly to Russell's sentencing, the district court also properly considered his mental impairments in crafting its judgment. During the sentencing hearing, the district court acknowledged Russell's cognitive defects 3 separate times, and even expressly stated and described them as Russell's, quote, most significant piece of mitigation. That recognition was not undermined by its simultaneous belief that his malingering was itself aggravating. Such an approach was neither contradictory nor ambiguous, and instead it was rather straightforward. The court found Russell's legitimate impairments extenuating, but his intentional exaggeration of those impairments as the opposite. Both sides of that coin were relevant to Russell's history and characteristics, and therefore proper considerations under 3553A. When the court issued its sentence, it thoroughly explained its reasoning under the 3553A factors. In particular, it emphasized the seriousness of the offense, including the large number of robberies, the violent and destructive nature of those robberies, the high monetary loss, and the impact on more than 40 individual victims. That explanation both allows for meaningful appellate review and promotes the perception of fair sentencing. Finally, regarding Terrence Williams, the government has conceded that as it is presently constructed, Special Condition 13 is unduly vague, particularly as it relates to the terms risk and another person. We therefore agree that a limited remand is appropriate to allow the court to remedy that deficiency.
Is there something we can remedy here rather than remanding, or is remand appropriate?
I think remand is appropriate here, Your Honor. It's up to the district court to articulate what specific risks it felt it needed to address by imposing the condition. The court can certainly provide guidance on particular language that it might find helpful in avoiding future appellate issues like this one, but I think ultimately the decision to impose the condition and the rationale for it should fall to the district court. Therefore, pending the court's questions, the government respectfully requests that you affirm the district court's judgment as it relates to defendant Russell, and you issue the limited remand as it relates to defendant Williams.
Thank you, Mr. Maurer.
Thank you.
Mr. Shavari, we'll give you a minute in rebuttal, and then we'll finish with Mr. Hillis.
Thank you, Judge. Very briefly, as to the question pertaining to the focus on malingering, but what evidence is there of Mr. Russell's ability to support his counsel in his own defense? Dr. Jaco testified that Mr. Russell had only a rudimentary understanding of the roles of key courtroom participants. He was uncertain as to his own attorney's role. He had a lack of understanding of what would be helpful to discuss with his attorneys during the preparation of his defense, the role of the prosecutor, as well as his ability to identify his rights as a criminal defendant. Compare that to the testimony of Dr. Munkin, who again did not retain his notes. He had no record of what questions he posed to Mr. Russell regarding the legal system, and there was a decided lack of any evidence that would allow the district court to have made an empirical decision. For that reason, we think that the district court erred in that regard, and I see that I'm out of time.
Thank you, Mr. Shavari.
Thank you.
Mr. Hillis, we'll turn to you.
Thank you. I would note that the condition that's at issue here has fallen out of disfavor. We don't see it often, and that may be an indication of the wisdom of running with the herd for district courts across the circuit not to delve back into this condition that appears to be disfavored for all of its ambiguity, overbreadth, non-delegation, concerns of these types, not to mention compulsory government speech. So that is the highlight of the rebuttal. But the other thing I'm remiss for not mentioning earlier is I do appreciate the court allowing me to appear remotely. So thank you all.
You're welcome. Thank you, Mr. Hillis. Thank you, Mr. Shavari. Thank you, Mr. Mauer. The case will be taken under advisement. We'll now proceed with Appeal 24-2931, United States versus the Town of Thornapple. And we'll begin, Mr. Wanek, with argument from you.
Thank you, Your Honor. May it please the court, Nicholas Wanek on behalf of the appellants in this matter, the Town of Thornapple. Your Honors, we are here for one simple question today, to answer what on God's green earth a voting system is under the Help America Vote Act of 2002. But the real issue here...
Well, my understanding is that the town uses a paper ballot system, right, for voting?
Correct, a paper ballot system that is then hand counted. Now, it is
right,
the...
Hold on. So it's a paper ballot system that after the vote is taken is placed into the locked box and then it's later hand counted. Is that correct?
Correct, Your Honor.
Okay. So the question is whether or not a paper ballot voting procedure like that one could be defined as a voting system, I take it.
That's right? Correct.
And so I know that you delve into the definition of voting system and the various arguments that both sides make. But I also noticed that the statute contains this phrase, paper ballot voting system, right?
Yes.
And so, in my mind, just looking at it from a purely textual basis, paper ballot seems to be an adjective phrase modifying voting system, much like a red car. Red would be the adjective modifying car. So why doesn't that just end the case? A paper ballot procedure is a type of voting system, which is how to make most sense of the phrase paper ballot voting system. Why is that wrong?
Well, Your Honor, I think it does underlie some of the confusion when you look specifically at that portion of the statute. I think if you look in the broader context, what you'll see is when we define voting system, we're first starting with the electronic, the mechanical, and electromechanical systems that are being employed. Now,
but if the question is what did Congress intend by voting system, and actually the specific question is whether Congress intended paper balloting to be a type of voting system, the phrase paper ballot voting systems seems to address that head on, doesn't it?
No, Your Honor, I don't think it does, and I think, again...
Well, then if the voting system does not encapsulate or include a paper ballot system, what definition would you give to paper ballot voting system?
Your Honor, it may be a voting system, but it is not a voting system for the purposes of the requirements that a voting system must meet under the statute.
But that phrase is within the same statute, and so you're relying upon the definition of quote-unquote voting system that's in the statute, and certainly Congress must have, at least within the same statute, intended the same words to mean the same thing.
I think they do mean the same thing, Your Honor, in terms of it might be a voting system in the colloquial sense, but not in the statutory sense under the language of the statute.
Well, no, then you're saying that Congress is using two different definitions of voting system, right? Here, Congress defined voting system and then used that phrase throughout the statute. So, again, I'm trying to figure out, if we apply the definition in 21081B, voting system defined, and then we apply that to paper ballot voting system, under your theory, then that phrase would be nonsensical.
No, Your Honor, I don't think it's nonsensical. I think it's
then what would it mean?
Your Honor, I think it's just separate to recognize that, in fact, municipalities may be using a quote-unquote paper ballot system, but that's not what Hava's
It doesn't say paper ballot system. It says paper ballot voting system.
Correct, Your Honor.
Right.
But I think it's important to understand where voting system defined comes in the greater context of Hava. This is in Title III, so we're in Section 301. Hava is at its core, and we can go ahead and look at exactly the first sentence of the Act, to establish a program to provide funds to states to replace punch card voting systems. That's really what Hava was about, and I know that both sides in here have pointed to the congressional record. I don't think we have to go that far. I think the statute itself is clear enough.
Mr. Wanek, let me interrupt you, because part of the decision we've got to make based upon the statute 21081(3)(b) is whether the and between subsection B1 and B2 should be deemed conjunctive or disjunctive. As I understand your argument, you're saying that and should be conjunctive. Wouldn't that present real challenges for the rest of subsection 1 and subsection 2, that every time the word and is used, it's in the conjunctive?
No, I don't think it does, Your Honor, and I think if you're going to look specifically to the next sentence that comes after, we're looking at the practices and associated documents used.
Well, let me interrupt you there. So then, if the and at the after 1C and the and after 2D mean the same thing as the and after 1D, so if it all means conjunctive, then a voting system would have to meet all the characteristics in B1 to qualify as a voting system. And doesn't that upend the way the statute is defining a voting system?
No, Your Honor, I don't think it does, because this again turns back to what are the voting systems that Hava is trying to address here. This was not meant to be a sort of nationwide blanket regulation that applied to every voting system that one could conceive of. This was to make sure that when we're replacing, dimpled chads and all the other things that went wrong with the 2000 election, we were making sure that the machines that Congress is spending a lot of money on at that time, that those meet the requirements, that these new systems that are being rolled out are not going to leave elderly and disabled voters still unable to effectively cast their ballots.
Let me ask a real pragmatic question. There was an area of Thornapple's voting area for disabled, those who were disabled.
Correct.
There was not a machine there, or at least a functioning machine. We know that from the Webster Declaration, correct?
Correct, subsequent to the town of Thornapple's June 2023 decision when they stopped employing that machine.
So if a working machine had been present at that location, then the town would not have been allegedly in violation of the statute, correct?
As I understand the government's position, yes, that is correct, Your Honor. This is simply a matter of the government trying to return use of this machine, and I don't really want to get into the irreparable harm prong. I know that's been well briefed, but the city made this, or the town rather, made this decision for a reason, and part of that consideration was the financial burden, and that's in the record.
Mr. Wanna, can I go back
Go ahead.
to Judge Brennan's question, please? I want to make sure, I think you were agreeing with the premise of his question, that if the and after 1D in section 301 is conjunctive, that every other and in section 301 has to be conjunctive as well. Did you agree with the premise of that question?
Yes, I agree, and I think that tracks logically when we're talking about what a voting system is. You know, some of these other requirements don't seem to make much sense if you're not employing an electronic, a mechanical, or electromechanical system. You know, if you're not using one of those things, D, to determine specific system changes to be made, that seems a little jargony for the purposes of a paper ballot that's then going to be hand counted.
Does the record reveal whether or not a printer was used to create the ballots?
I do not believe the record reveals that.
Okay.
Would that
I'm sorry, go ahead.
Would that satisfy the mechanical if a printer was used to make the ballots?
Possibly, Your Honor. I think it would.
And how do you explain the inclusion of paper ballots in 2E to make available any material to the voters?
Well, I think that goes kind of to Judge St. Eve's question of how are the ballots themselves being made available. Again, the record is not entirely clear on exactly what happens when you walk into one of these polling places, especially after the decision. But perhaps you have to sign in on a computer to sign the voter roll. I don't know what processes they are employing. I just know that they have not been using this machine. And so with my remaining time, I do want to reserve rebuttal.
That's fine. We're going to give you more time on rebuttal. Did you have any further questions, Judge?
I did. With regard to I just wanted to make sure that I understand your position with regard to the irreparable harm prong. So as I understand it, the testimony of Ms. Pinault is that when someone is unable to fill out a ballot themselves because of a particular disability, that she assists them in filling it out, right?
Correct, Your Honor. There are 3 specific examples from the record. Now, one of them is not actually Ms. Pinault assisting. It's noting that the daughter of a blind woman did assist her. But I'm glad you brought that point up, because I think it's important to note that, you know, the court's decision below really was reaching out and saying that the whole point of this is not that, you know, we need to make sure this machine is here. It's that we need to make sure that this machine is here so that everybody has access to the secret ballot to vote sort of on a level playing field. And I think that is a completely unworkable standard here. I don't think there is a piece of technology on this planet where you can possibly, you know, allow everyone to vote on an equal basis. I don't think an amputee could, for example, use these machines. And if you're going to go with the logic of the court below and the government's position that a voting system is whatever system the municipalities use, and it's a direct quote from the trial court, you're going to find that the types of assistance that are guaranteed elsewhere in our federal laws under the ADA and the Voting Rights Act, you're going to find that poll workers are less likely to provide that assistance because they're worried about this new overbroad interpretation of HAVA, which has not been present in the nearly 20 years that HAVA has been around.
Well, I guess my question is a bit more targeted on the record than that. The statute talks about when it talks about accessibility for individual disabilities, that the system has to provide the same opportunity for access and participation, including privacy and independence. So I'm just looking at the privacy part. How would you define privacy as used in the statute?
I think privacy means that you are casting your ballot in a manner that no one else is aware of how you've chosen to cast that ballot. And again, I don't think that is feasible when we're talking about certain categories of disabled voters.
Okay, thank you.
We'll give you some rebuttal time, Mr. Wanek.
All right. Thank
Mr.
you, Your
Wang will now recognize you for argument on behalf of the appellee.
May it please the court, Christopher Wang on behalf of the United States. The district court's order granting a preliminary injunction should be affirmed. The court correctly determined that the United States is likely to succeed on the merits of its HAVA claim and did not clearly err in finding that the United States is likely to suffer irreparable harm absent injunctive relief.
Mr. Wang, it's not the clearest interpretation with regard to the use of the word and, the conjunctive disjunctive. Is it the government's position that the and that occurs after B1D should be interpreted disjunctively versus the and at the end of B1C and 2D? Those should be interpreted conjunctively.
Our position is that they should be interpreted disjunctively everywhere in B1.
All right. Let me pose a similar question to you, Mr. Wang, that I posed to Mr. Wanek. If the machine had been operable and in the area of the voting municipal hall reserved for individuals who are disabled, that option enough would have been sufficient to satisfy the law. Is that correct?
That's correct. The option to give individuals with disabilities the right to vote with privacy and independence, that would be sufficient, assuming it was operable and available.
Right. And we know from the Webster affidavit that the machine was not present. Is that correct?
During the elections at issue, April and August 2024.
Okay. Part of the challenge that we have here is on the irreparable harm component. The record seems to be somewhat thin, somewhat underdeveloped. We've got the Webster affidavit, we've got the statistical information that's coming in from the attorney, and then we have the pinout testimony, which Judge Peterson found very credible. And from the we weren't there obviously, but from the transcript, she seems to have been on top of things. With those three things, do we have enough to know that there was a harm to the town that would have satisfied the standard?
Yes, Your Honor. Again, I'd like to remind this court that this is a clear error standard of review. Based upon the evidence, the demographic evidence of individuals with disabilities in Wisconsin, in the two specific instances of individuals who needed assistance to vote, the district court did not clearly err in concluding that Thornapple has individuals with disabilities who need assistance in voting. Defendant's failure to provide an accessible voting machine is likely to irreparably harm the fundamental right of these individuals to vote privately and independently. And that, once again, I'd like to emphasize that it's a fundamental right to vote privately and independently that HAVA guarantees, particularly given that this population can fluctuate between elections and anyone can become a member of this demographic at any time. For example, you could have a stroke, you could get into an accident that blinds you temporarily or permanent, and you could need to use an accessible voting machine.
And that's certainly a distinguishing argument. The elephant in the room here, though, is we've got an 800-person town with 400 voters. Ms. Pinow says there's 0 to 1 disabled. I think the record shows maybe 1 to 2 disabled. The statistics are interesting background, but why does the government have the interest in this particular case?
The government has a basic interest in enforcing HAVA wherever it's violated. Thornapple's argument is basically that the United States has to show actual harm. The standard is a likely harm, not actual harm or harm that is certain to occur.
And you're relying on the Whitaker case, our Whitaker case for that?
Yes, Your Honor. And Pinow's testimony that 0 to 1 disabled individuals attempted to vote in Thornapple actually supports the government's case because it's an acknowledgement that in certain years, at least one individual who was disabled required assistance to vote. Your Honor, if I would like to turn back to the likelihood of success on the merits, if I could. Judge Lee is exactly right that Section 301 explains how paper ballot voting systems can satisfy the statute's requirements that voters be given the opportunity to correct overvotes and voting errors before a ballot is cast and counted. These provisions necessarily assume that such a system is a voting system under Section 301B. Defendants do not attempt on appeal to explain these provisions, and this omission is fatal to their argument. Defendant's argument fails for several additional independent reasons. As Judge Lee pointed out, a pencil used to mark a ballot and a lock used on the box to store ballots securely are both mechanical devices that fall under B1. Second, in terms of Judge Brennan's argument about the meaning of the word and, We believe that the best interpretation of this section is that Congress listed all potential components of a voting system in Section 301B, indicating that the word "and" connecting B1 and B2 is a disjunctive. Congress intended to capture all important aspects of the voting process, including before, such as inspection and testing, the actual vote, and after, audit the actual vote, that might not be covered by the general phrase, whatever voting system a municipality uses, as Thornapple proposes.
I'm having difficulty reconciling your earlier answer, though, that if the "and" at the end of 1C is also to be disjunctive, and the "and" at the end of 2D is also to be in the disjunctive, just like the "and" at the end of 1D, joining the two, if those are all to be disjunctive, doesn't that create a problem for our reading of B1 and B2?
I don't think so, Your Honor. B1 is supposed to address the equipment that possibly could be used in the voting system that might not necessarily be used if you're basically accepting Thornapple's argument that they don't have any mechanical equipment.
So it could be A, B, and C, but wouldn't necessarily satisfy D, but that's okay under Harvard?
That is okay. I'm looking at the word combination in B1, the total combination of mechanical, electromechanical, or electronic equipment. That implies that they don't. A voting system does not necessarily have to include one A, B, C, and D. A third reason not to.
Mr. Wang, I want to go back to the lock comment. The district court, as you acknowledged, focused on the lock on the voting box, qualifying as a mechanical requirement. It seems kind of odd to me that Congress would intend that whether or not there's a lock or not would be a dictating factor for voting.
Well, Your Honor, we don't have any legislative history indicating what Congress thought mechanical meant.
I understand that, but common sense that whether or not you have a lock on a lockbox is going to dictate whether it's mechanical?
Your Honor, I think it's certainly an colorable argument. That's why we made it in our brief. It's just one way to affirm the judgment of the order of the district court on this particular factor. There are several other independent reasons. If you don't accept the argument that a lock on a lockbox is mechanical, there are all these other arguments that we set forth in our brief.
Is there anything in the record about how the ballots were printed, how they came about? Were they used, was a printer used for them?
I don't know if there was. I think certainly if a printer was used, that would satisfy B1 in terms of because it's a mechanical device that's used to actually print the ballots. But I don't know if the record indicates how the ballots were printed. The third reason that I would say that supports the government's position as the defendant's interpretation would leave a gaping hole in Section 301's coverage. Section 301 sets forth uniform standards for correcting overvotes and voting errors, as well as providing the same opportunity for access and participation to all voters. Defendants provide no reason to apply these requirements to all methods of voting other than paper ballots. I know the defendant's counsel brought up the issue of the ADA and the Voting Rights Act providing sufficient coverage to protect individuals with disabilities. Certainly, federal statutes can provide overlapping coverage. There's no canon of statutory construction that requires a court to interpret two federal statutes in a way that they cannot overlap in coverage. In this case, HAVA requires an accessible voting machine be available and ready to go at every polling place without exception. And the ADA does not address other Section 301 uniform requirements applicable to voting systems, such as the ability to correct errors and overvotes before a ballot is cast and counted. And I guess with the limited amount of time I'd like to address opposing counsel's argument that HAVA was intended only to apply to the problems with the 2000 election, specifically punch cards. Although that's certainly a reason for Congress to have passed HAVA in 2000, there's no indication that Congress intended for HAVA to apply only to those mechanical systems. In fact, HAVA's preamble states that it was intended to establish minimum election administration standards, and the Title III itself indicates that it was to establish uniform election administration requirements. So certainly that indicates that it applies to paper ballots, mechanical types of voting. Your Honor, I see that my time is up.
There was no mandatory mediation here with the magistrate because it was 1 week between the complaint and the hearing, correct?
I don't know why it was. I know that was a very abbreviated schedule because of the November 24 election.
Thank you, Mr. Wang. We'll now move Mr. Wanek to you for 2 minutes for rebuttal.
Your Honors, the only real point I have on rebuttal is that I still feel, even at this stage of the case, after we've been through the district court, we've now briefed this issue with repeated pleadings from both sides, and we're now here arguing today, is I still do not understand how the government can stand here and say that a meager pencil that they hold in their hand is a voting system under HAVA. I think what you heard from counsel shows just how far they're willing to go to expand that language to cover something that Congress never intended to. And I think this goes to Judge Saini's point when you brought up the fact that a mechanical lock wasn't really what Congress had intended. I would even go further, and I would say that I don't know why the voter would have any interaction with the lock to begin with, because I think we'd have bigger election integrity problems if that were the case. So this really stands, and the government pointed out on page 20 of its brief, it said that a pencil is a mechanical device. That's really what this case boils down to, and I just do not think that the statute itself, the legislative history, or quite frankly, any workable standard that this court could provide in terms of how to manage elections moving forward, I don't think any of that supports using such a low threshold to grant the government jurisdiction to seek the injunction that it did in this case. And then I will turn over to your questions.
Thank you, Mr. Wanek. Thank you, Mr. Wang. The case will be taken under advisement.
All right. Thank you, Your Honor.
We'll move now to our final case of the morning. This is Appeal 23-2881, United States versus Kevin Hodge. And we'll begin, Ms. Skian, with oral argument from you.
Thank you, Your Honor. May it please the court. My name is Anne Therese Skian, and I represent the appellant, Mr. Kevin D. Hodge, as supervised by Robert Palmer of the Notre Dame Law School. Your Honors, today we ask that this court vacate Mr. Hodge's sentence and remand for resentencing because of procedural and substantive error. The district court procedurally erred because it failed to explain the reasons for its sentencing, specifically ignoring arguments in mitigation related to the safety valve and the situation with Mr. Hodge's family.
Ms. Skian, was it enough that the district court here reviewed the PSR, any objections to it, the safety valve concept was addressed in those, even if the district court did not make a statement on the record with regard to the safety valve?
Your Honor, this court in Lyons found that acknowledging the PSR in the briefings in the case was not sufficient to address a primary argument in mitigation. And so even though that was reflected in the PSR, that was not sufficient here because this was a primary argument in mitigation for Mr. Hodge.
In Castaneda, this court did say you must address the safety valve. At the same time, that circumstance was slightly different. Here we have a below guideline sentence. Does that make a difference?
That does not make a difference in this case, Your Honor, because the length of the sentence, I think, would speak to substance. And this court found in Lyons also that even though in that case the defendant had received its fallback sentence, which was the minimum minimum guidelines sentence, he did not thereby sacrifice his right, I think they used the word forfeit his right to a procedurally accurate sentencing, including a statement of the reasons for that sentencing. So here I do not think that would be relevant. Further, I believe
that the court didn't sufficiently consider his wife's medical condition. The court expressed sympathies about her situation. The court noted it had continued sentencing, I think, 6 times because of the situation. But it went on to explain that given the enormous amount of drugs involved, that wasn't sufficient. Why isn't that enough on that particular issue, namely the wife's medical condition?
Thank you, Your Honor. We do not contend that the court ignored or somehow missed the issue with his family. Instead, they engaged in a different kind of inquiry than what we're asking them to do here, an incorrect inquiry. In United States versus Schroeder, the court had a similar situation where the defendant's young child was immunocompromised and they had an issue with child care if he was to receive the sentence that the state wanted. In there, the court said, we understand this is very sad, however, you should have thought about this before you committed a crime, is basically what they said. And the court here remanded that sentence because the relevant inquiry is whether or not, and I'm pointing here to the Sentencing Guidelines Manual at 5H1.6, whether or not there's a difference in the situation from a comparable defendant. This court has recognized that in almost every sentencing situation, the defendant's family has been impacted. That's not necessary for the court to really address. But when there is something different here, the court should address that difference, and the court here failed to do so.
Why wasn't it enough, and why doesn't it distinguish it from Schroeder? Because the court went on to say, despite these medical reasons, you were involved with a lot of drugs here. I mean, that's what it seems like the court is saying, that the excessive amount of meth involved in this case outweighs that.
Your Honor, I would point you here to pages 26 and 27 of the appendix. In the transcript where the court asked twice, was why did you get involved with drugs whenever you knew your wife was sick, or the woman who would be your wife was sick, and then goes back and says, but didn't she have these medical conditions when you're committing these crimes? A very similar inquiry about guilt was found in Schroeder. In a similar way, the relevant inquiry wasn't how much drugs he had, or the fact that he had committed this drug crime. It was whether or not there was a difference in his situation with his wife. And Your Honors, I would then turn back to the safety valve argument. Here, Mr. Hodge was eligible for safety valve relief. The statutory minimum was 120 months, which is where he was sentenced. The sentencing court did acknowledge that whenever they were calculating the offense level for the guidelines, that he was eligible for safety valve relief. They factored this in. They gave him a 2-point reduction under paragraph 5C1.2. However, they never once again discussed the possibility of a safety valve when it raised the fact that the statutory minimum was 10 years. The court then heard argument from opposing counsel that while Mr. Hodge was safety valve eligible, they felt that going below the statutory minimum would be inappropriate. Mr. Hodge countered that he did think it would be appropriate in this circumstance because of the extreme circumstances of his family and other mitigating factors. And here we have where the court sentenced exactly at that statutory minimum, but has provided no explanation for why it chose that minimum, if it considered the safety valve, if it rejected the arguments based on arguments by opposing counsel. It is simply unclear from the record how the court chose to make that decision.
So is your position that under 18 U.S.C. 3553F, right, which is a safety valve provision, it says that a court can sentence regardless of the statutory minimums if the court finds at sentencing? Is it your position, I take it, that the statute requires a court to make a finding at sentencing that a defendant's safety valve eligible, and there's no finding here?
Yes, Your Honor. It is unclear whether in this circumstance, and I don't want to speak more broadly and say in every other circumstance with different transcripts, but here in this sentencing, the court needed to find some kind of decision or indicate why it chose or chose not to go.
Because it's not enough that the government recommends it. The court has to acknowledge the recommendation and find the safety valve applicable.
There has to be at least some consideration of it, so we can understand and properly review why the district court judge either chose to apply or chose not to apply that sentencing. In Your Honors, I would ask to save the rest of my time for rebuttal.
Very good. Thank you, Ms. Ski, and the remainder of your time will be reserved for rebuttal. Mr. Sanders, we'll move to you on behalf of the appellee.
Good morning. May it please the court. Counsel, David Sanders on behalf of the United States.
Mr. Sanders, if we could start, if you wouldn't mind, with my question with regard to the language in 18 U.S.C. 3553F that says if a court finds at sentencing, how does the transcript here, does that comport with that requirement?
Could you rephrase that in?
Right, how does the transcript here give us confidence that the court made such a finding as required by 3553F?
Yes, Judge. In this case, the record does provide adequate assurance to this court. I'll point out a couple of things. One, the Judge Gilbert sentenced the defendant to a term of supervised release below the statutory minimum. The judge also mentioned, I'm not going to sentence you to time served. Imprisonment is, there's got to be some punishment. And I mention that because it shows the judge knew that he was authorized to go below. He entertained the argument that was extensively briefed in sentencing memorandums at argument. He entertained arguments about going below that statutory minimum. Judge Gilbert would not have entertained those arguments had it not been relevant. So I do think there is adequate assurance in here because there was no confusion in the record that he could not go below that mandatory minimum. And that's a big distinguishing factor in Castaneda.
How do you respond, Mr. Sanders, to the statement of reasons? And this is what troubles me. In the statement of reasons, which I think you agree we can look at and consider, the court checked the box that states, quote, one or more counts of conviction carry a mandatory minimum term of imprisonment, and the sentence imposed is at or above that applicable mandatory minimum. There's another box underneath that says the court went below because of the safety valve, acknowledging that the safety valve was at play. I'm troubled by checking this box because that suggests the court was applying the mandatory minimum.
And I've looked at that too. I don't think there was any better option than option A here. Option C, the count says no count carries a mandatory minimum sentence. This count carries that mandatory minimum. Option B is what Judge, you indicated, has the safety valve checked under the subsection of B. However, Judge Gilbert is not going below the mandatory minimum here because even the guideline range was 135 to 168. He buried downward to 120, and he gave his reasons why. A tremendous amount of drugs was involved. So I don't believe there was a better option than A here because he did not go below the mandatory minimum.
That just gives me pause.
Yes, I apologize. But turning to also going back to the assurance, I do believe that this court has reasonable assurance, which is necessary here, that Judge Gilbert knew that the defendant was safety valve eligible. And then also the record clearly demonstrates that the court weighed all of the factors against the gravity of the defendant's offense and concluded that imprisonment was necessary because he was involved in, quote, a tremendous amount of drug distribution. And as this court is well aware, the district court enjoys wide latitude what weight to give those 3553A factors. And finally, as to whether the district court's below guideline sentence was substantively reasonable, the defendant bears a significant burden to establish that the district court abuses discretion when it fashioned its sentence, which the defendant has not done so. Pending any questions, the government would rest on its brief and ask that the court affirm the lower court's decision.
Thank you, Mr. Sanders. Ms. Skeen, we'll go back to you now for rebuttal argument. Let me start you off with a difficult question. Guideline range here was 135 to 168 months. Your client got 120 months. Government recommended, I believe, 144 months. Defense asked for probation. Do you have any understanding if your client knows that if we grant the requested relief of reverse and remand for resentencing, that sentence could go up? It's not an insubstantial amount of drugs we're talking about.
Your Honor, I have not specifically and personally discussed that with my client. However, I'm aware that by appealing this and requesting a resentencing, that is possible. We do believe that the relevant factors here would present a strong argument for a even lower sentence than this, but we certainly recognize that that is possible, and certainly recognizing that the district court in this would be sentencing, looking at those guidelines fully. I find it hard to believe that it would go up, but I recognize the possibility.
Thank you.
What's the status of his wife's health?
I am not aware of the status of his health in this moment, but I would point again to the status of his health at the time of the sentencing, which is what would factor into whether or not the court in that moment committed an error.
But to go to Judge Brennan's point, if he is resentenced, if we reverse and remand and he's resentenced and his wife doesn't have the same health challenges for one reason or another, that strong mitigating factor wouldn't be present anymore.
That is true, Your Honor, though I would say that even if she had received the kidney and the pancreas at that time, I don't think that her condition was so serious. She was already requiring regular dialysis. I don't think that she would suddenly be in phenomenal health. I think that it would still remain a mitigating factor. And even in that circumstance, I think that should we remove the family argument, I do think that the safety valve argument is very strong here as well.
He's got the 3 years on bond clean as well.
Yes, he does. Yes, he has 3 years. I believe it's 20, 21 or 22 clean drug tests. And I think that all of those things would factor into that resentencing. And I would like to point, just returning to the safety valve for one moment. This court, and when initially reviewing this case, in the order that they passed down, noted that there are many sentences between 0 and 120 months that the court could have considered. And under 18 U.S.C. 3553C, this court is, in a sentence of over 24 months, the district court, is required to say why they sentenced at that precise point in the range. And here I think that there are many different sentences that were not considered that would certainly be relevant, that would be required by procedural due process here. And if there are no further questions.
Thank you very much, Ms. Skeen. You've been appointed counsel, and you've done an excellent job, as has Mr. Sanders. And we thank you and Mr. Palmer for your representation of the client in this case.
Thank you very much, Your Honor.
The case will be taken under advisement.
Thank you.
And that will complete our hearings for the day.